And, as we are getting back, involved in trying to move towards some regular order and adapt to some of the changes that COVID has brought us, we'll continue to grow in our coordination and comfort. But, here at Hanger Law, we have always loved the partnerships that we've had with Keller Williams agents. And I wanted to provide a little bit of a brief overview of some of the changes in landlord tenant law, specifically aimed towards property managers and landlords. But as you know, in this market, there's a lot of investors taking advantage of real estate opportunities. And so even for agents that don't do work with rentals as a primary business area, understanding the law is going to be important to all agents. We find that people are taking taking properties subject to leases, and with the various moratorium, people are buying properties, where leases has expired, but they still are dealing with tenants in the property. So understanding where the law is just going to make every agent more valuable to their clients and their potential client base. And I want to provide a little bit of an update. And before I do that, I'd like to run through the fact that, Hanger Law has become well known for doing closings, being able to partner with agents in giving advice as far as drafting, well-written contracts, being able to navigate demands of other agents, and making sure that language in, PICRAs and PICA addenda, et cetera, will not result in hangups at closing. Being able to explain how the law operates. But beyond that, we are a full-service firm. We set up LLCs, we serve as registered agents, we help agents who are building and managing their own businesses. We're connecting the community with other business owners, and then are able to provide referrals. And when things go bad and a deal goes south, we provide litigation services as well, and try to ensure that your clients get the compensation when it comes to a return of an earnest money deposit. When there is misrepresentation, that precedes the sale, that you as an agent can refer to a full service firm with whom you already have relationships. Other related matters include estates. Just like leases, you don't have to deal in estate planning to be an agent that deals with property that's either held in an estate, or you have heirs, who kind of don't know what to do with the family property and are looking to sell. We're happy to help navigate that because we have the resident expertise. So we are a local law firm with offices on the peninsula and in Virginia Beach. We've got attorneys that all deal in real estate but have different areas of focus, and work together as a team to provide solutions for our agents who are our primary business partners. And our core values focus on relationships, results, and responsiveness. A quick look at our team. These are our litigating attorneys. I'm John in the center. Next to me is Brandon Goodwin. Brandon came off a federal clerkship and has a very deep knowledge of the law and how it works out at the highest level. Gina practices on the peninsula. She appears to, I guess, my right on the screen, and she's a managing attorney on our peninsula office and does a lot of real estate and litigation and represents property managers as I do. And Jess Elliott is the newest attorney to our team. She's on the far left, and she's doing a variety of real estate closings, remote closings, and litigation on both the south side and the peninsula. Now, into the property management aspect. You probably have followed some of the changes of the law, and the CDC had an eviction moratorium that had been very focused on eviction for non-payment of rent, which served as a freeze on a lot of evictions across the country. On August 26th, there was what has often been referred to as a striking down of the eviction ban. However, this isn't exactly true. The procedural posture was that a single federal district court had found the CDC to have exceeded its authority. That had been appealed, and a stay on that judgment had been ordered. And the Supreme Court refused to enforce the stay, which means that the actual case can proceed in the traditional, which is a lengthy appellate process. But across the country, courts are taking the very strong language of the opinion of the court, and you see it in red. We vacate the stay, rendering the judgment enforceable that the CDC has exceeded its authority. Now, in strict legal terms, that means that the judgment is enforceable in that district, but other courts are taking notice that the Supreme Court has said that it's likely, to win on the merits should it go up to the Supreme Court. And so they are treating the CDC ban, including in Virginia, as if it's unenforceable, but it's not exactly completely dead. It's sort of on life support and isn't doing anything, but it's not quite dead yet. So does this mean we can forget about it completely? Well, I would say no, that would not necessarily be a wise conclusion to draw, because courts in Virginia tend to lag the latest news cycle. And as you in the real estate business are always adaptable and flexible, the last 18 months has told us that we need, even in the legal community, to be adaptable and flexible. Courts, once they have adopted a new requirement, tend not to forget that requirement quickly. So it's important to understand how to effectively challenge the CDC affidavits and recognize that that will remain a useful strategy when tenants want to seek a COVID-related hardship as an exemption to an eviction, even if it's not strictly legally mandated from the top down. So where does that leave us? Well, traditionally, landlord-tenant law has been the province of state law between the common law courts and very recently, over the last 6 years, the Virginia Residential Landlord-Tenant Act, which is a creature of the Assembly. Now, typically, when changes to landlord-tenant law take place, it's in that General Assembly session that happens in January, February, March of each year. Oftentimes, if there's a major change in the law, it's debated, and there's input from industry groups like property managers and tenant advocacy groups. And then once it's decided on and signed by the governor in April, it'll have a delay in its enforcement, or I'm sorry, when it comes into to being active on the books, right? It will be July 1st, January 1st the following year, July 1st the following year is what's been most typical. But since the beginning of the pandemic, there's been anything but business as usual. And the most recent change is no different. On August 10th, the governor signed into law the Virginia budget, which went into immediate effect. And it kind of codified what had been temporary measures concerning heightened notice requirements. Rather than the old 5-day pay or quits, the 14-day notices for all landlords, whether or not you own 5 properties or 1, are now the law of the land, and it's here to stay at least through 2022. Now, there remains the bridge, or rather the expanding gulf between landlords that own or manage more than 4 properties and those that manage less than. So for the mom and pop, the middle-class couple, the military couple that owns 1, 2, 3 houses, and then have rented them out as they've moved up, they're still exempt from the newest requirement that landlords apply for the rent relief program prior to proceeding on eviction grounds. But again, this applies only to those evictions that are proceeding solely on the basis of failure to pay rent. So what does this mean? It means that if you're going to pursue an eviction and your sole basis for that eviction is non-payment of rent, if you are a landlord or a property manager managing more than 4 properties, then you need to at least apply for the rent relief program and wait until the tenant is rejected, or until 45 days after that application with no response from the rent relief program. We'll go through the law here and then kind of decipher, what does that mean? Are there exemptions? Does that mean that your landlord is stuck? What does it mean if there is less than 2 months remaining in the program, et cetera? But let's go through the law and take a look at what it says. It says that if rent is unpaid when due, or for payment under the terms of a payment plan is unpaid when due, the landlord shall, pursuant to 55.1-1202, serve a written notice on the tenant that informs the tenant of the Virginia Rent Relief Program and provides the website address and statewide telephone number. The written notice shall provide information on how to reach 211 to determine whether there are any other available federal, state, and local rent relief programs. And I remind you, I provided a number of updates last summer to the 2020 updates to the VRLTA, that's in addition to the requirement that any eviction notice provide information on how to contact legal aid. The written notice shall also inform the tenant that the owner, landlord, or owner's license agent shall apply for rental assistance on the tenant's behalf within 14 days of serving the notice on the tenant, unless the tenant pays in full, enters into a payment plan, or informs the landlord that they have already applied for rental assistance. The landlord shall apply for rental assistance on behalf of the tenant no later than 14 days after serving the written notice on the tenant, unless they receive the full amount owed by the tenant or confirmation from the tenant that the tenant has applied for rental assistance before the 14th day, or they've entered into a payment plan with the tenant. If the tenant has applied for the rental assistance, the landlord shall cooperate with the tenant's application by providing all information and documentation required to complete the application, including but not limited to the W-9 IRS form and any supporting affidavits. On brief, what does this mean? It means that when you provide the eviction notice, the 14-day pay or quit, notify them that you, the landlord, will be applying for rental assistance on the tenant's behalf. Now, in order to do that, you often require the tenant's assistance. So we'll talk about that a little bit later on. If they inform you that they have applied or that they don't qualify, well, you're probably going to want to provide an affidavit to that effect while preparing your unlawful detainer package at court, saying that we provided notice, here is a copy of that notice, and my tenant has informed me that they have applied or do not qualify in order to proceed for an eviction. In initial application, this is the rest of the law, and this will be the last slide that's merely reading the law. An initial application, the landlord tenant does not, sorry, I've got a window blocking that, does not receive written approval from the Virginia Rent Relief Program or any other federal, state, or local rent relief program within 45 days of when the application for assistance is made by the tenant or the landlord then may proceed to obtain possession of the premises as provided in 55.1-12.51. A brief aside here, if you have any experience with the courts, you know that they're a little bit backed up. I'll talk about what Hanger law does in our standard eviction processes, but as a brief note, it does not say that you have to wait to file, but you cannot actually get the eviction. So what you may consider doing is filing for the unlawful detainer with 45 days out past the application of that for rent relief, right? And have that date on the books. And that can often be an effective negotiating tactic with a tenant that is not paying rent, having a court date. The court filing fees are about $52. So often that's a small price to pay to gain a negotiating advantage in order to get a tenant to either pay up or move on. Continuing. For any subsequent application, if the landlord tenant does not receive written approval from the Virginia Rent Relief Program or any other federal, state, or local rent relief program within 14 days of submission, the landlord may proceed to obtain possession of the premises. If a landlord who is not, if a tenant who is not paid in full or entered into a payment plan with the landlord within 14 days after the written notice is served, refuses to apply for the rental assistance and also refuses to cooperate with the landlord providing information and documentation required to complete the application made by the landlord, or if such tenant is determined ineligible for rental assistance, or there are no longer funds available, the landlord may take action to obtain possession of the tenant's dwelling unit. That's important because the previous 3 slides provide all of this, the landlord shall language, which seems to be pretty onerous as far as the requirement on the landlord, and it is. But that's not the final word. If a tenant doesn't cooperate or provide you the information within 14 days of that notice, well, then it says here that you can proceed for eviction. So you can send the notice, send an application, and often a tenant who's not paying their rent is not, cooperating with their landlord on other things. And if they don't get back to you within 14 days with information that you need, you can proceed to the eviction. So the question is, after reading this, are your landlords stuck waiting around for months when not in receipt of rent? Not necessarily. The slide says this order, but it also means the law only applies to evictions for non-payment of rent. Often tenants who are not paying rent are in default of other provisions of the lease. Even during this moratorium over the last 18 months, I and other attorneys at Hanger Law have been successful at getting possession orders for our landlords. It's often because we read the law and see what the law applies to and what it doesn't. So if a tenant is in a 6-month lease or a 1-year lease and they're coming up on the end of the lease, there's nothing in this law that requires landlords to renew the lease. And so if a tenant has failed to pay rent and it's September 20th and that lease expires on October 31st, you can immediately provide your notice of termination, notice of non-renewal, notice to vacate effective October 31st, and file unlawful detainer with a date for the first week of November. And you can claim rent that's back due and late fees, etc. And you're not terminating the lease for non-payment of rent. You're terminating it because it's been expired. Now it's expiring with rent due. Oftentimes the judge will say, is this just an end around of the moratorium? This is an end around the law. Well, no, Your Honor. In fact, we're willing to what's called bifurcate the hearing, which means essentially take what is one cause of action and split it into 2 hearings. Say, Your Honor, what I've had a great deal of success, especially in Virginia Beach. Say, Your Honor, my client is not seeking rent damages at this time. The tenant will be entitled to every defense to which they're entitled at a contested hearing. However, today my client is seeking possession of the premises. Often landlords are willing to forgive some amount of late rent if a tenant will voluntarily vacate the premises or at least gets out so they can get a paying tenant in. And communicating some flexibility to the judges and kicking, in an environment where, is this moratorium going to get extended again, et cetera, the judge would be willing to grant a possession order if he didn't have to rule on the rent issue and kind of kick the can out a little bit on that. And nevertheless, I've gotten judgments in the order of $20,000, $5,000, $7,000, $26,000 on final rent damages hearing once we were in possession of the premises. And then you have the opportunity to put on evidence, the judge to say, not only is this, person 6 months behind on the rent, here's the condition of the premises when they actually did leave. This lease, is entitled to attorney's fees, et cetera, et cetera. And if your landlord is flexible on saying, hey, listen, this moratorium or this budget or whatever law it is that we're operating under is not completely prohibiting you from getting possession, but you got to wait on your rent. If they're willing to wait and they're willing to pay for an attorney, often they can get that judgment. But let's discuss other areas of the lease, which when you have a well-written lease that clearly identifies the obligations between the tenant and the landlord, the judges, at least here on the south side, have often been willing to enforce a well-written lease when you have a tenant who is violating a number of provisions or any one of a number of provisions, including behavior or conduct that threatens the health or safety of other residents or neighbors, damages or poses an immediate and significant risk of damage to the property. This is one that's a big deal, right? Most of your leases require the tenant to let in the landlord for reasonable inspection. And I've had a lot of tenants try to say, oh, I'm concerned about COVID. Well, the landlord still has a right to make sure that their property is protected. And if you reported it, if this tenant's complaining of things, you reported, this a water leak, I have a responsibility to go in there and fix it. Now I'm going to do it quickly as a property manager before it damages the property. And you haven't let me in, so I'm going to the court to terminate this lease because you have unlawfully barred the landlord entry to the premises. And will hold you liable for any damage to the property. And sometimes, if you have an attorney involved and the attorney is the one communicating this to the tenant and explaining what the detrimental impact of having an eviction on their record will do to their future rental prospects, what having a money judgment on their record will do to their ability to buy a home in the future, they'll often become a lot more willing to negotiate, even if they've been stonewalling the landlord or a property manager. Other areas in which you can terminate a lease is for violating a building code, health ordinance, or similar regulations. So if you've got any sort of violation that's happened and you've got an inspection showing that at the beginning of the property, property was habitable, no defects, et cetera, and we'll talk about walkthrough inspections at the end of this presentation. And then you now have a violation, that's a basis for terminating the lease. And finally, violating any other contractual obligation other than the timely payment of rent or similar housing related payment. So often your leases will have a number of tenant obligations that include maintaining the property. There's generally some breakdown between the landlord and the tenant as to what the responsibilities are. And when a tenant fails to meet those responsibilities, the landlord is entitled to terminate the lease. So What does this highlight? Well, it highlights the need for a well-written lease. That clearly articulates the responsibilities between the parties and has clear enforcement mechanisms. And when I review a lease or write a lease for my landlords or property managers, I attempt to make it very clear what it is the tenant is required to do and what the consequences will be, which termination of the lease and liability to the landlord will follow should the tenant fail to meet those obligations. And it also highlights the need for effective notice when a tenant fails to meet his or her obligation of the law. Notifying the tenant that any rent received is received with reservation or enforcement of all other rights. I've seen a number of landlords that have been representing themselves, many of whom have been in this sphere for a number of years and done very well without an attorney, having their cases kicked out of court or sent back or sent to the back of the line because they had ineffective notice, because the notice didn't meet the heightened requirements of the law. And I've often seen tenants that are getting legal aid. And so the tenant is refusing to pay rent to the landlord, receiving funds from the government in some form or fashion, getting free legal advice to try to protect them while they're breaching their lease and not paying rent. And then the landlord has to pay to get an attorney to enforce their lease. I've been very successful in doing that, and I don't think that I've lost a single case, either under a tenant's assertion or a contested eviction against legal aid, but it's still a hassle, and I don't work for free. And so even when you get that possession order, when you get that judgment for money damages, it often takes some time. It's still worth it. Nearly every case that I've been involved in, it's been very much worth it to the landlord, but it's not cheap and it's not easy. And it's, my estimation, often it's not fair where the balance of protections lie between the landlord and the tenant. So an effective, honest attorney does not sidestep the clear intent of the legislature to protect tenants that are in financial difficulty. Understanding the state of the law allows property managers and landlords to more quickly and effectively move on from problem tenants despite heightened requirements. These are some examples, and that doesn't violate confidentiality for me to discuss them briefly as they're a matter of public record. In Norfolk, we had a number of tenants who were not paying their rent, and when we had an eviction granted, they did a CDC affidavit, and we challenged those affidavits. And these were tenants that had legal aid. Now, I had gotten this case from another attorney's office that didn't necessarily specialize in landlord-tenant law as specifically and effectively as we have sought to do in Hanger law. And so the initial proceedings had been filed last fall. That was before the House budget bill of last fall, the House bills 5016, 5000, and 5011, that when taken together created the initial 14-day requirement, notice requirement. And so the judge, was inclined to follow legal aid's, opinion that the notice requirements applied retroactively to evictions, filed. We were able to get the judge to set aside that argument and challenge the CDC affidavits on their face. And under cross-examination, it became clear that there had been no COVID-related loss of income, and they were in alternate material breach of the lease because that lease had been well written and limited the occupants to the named tenants, and the named tenants had been letting somebody else stay in the property. So I was able to get the lease terminated. We were able to get a settlement, and we were able to represent effectively despite having other lawyers involved on the other side, despite using the CDC affidavits. But it took some effort. Gardner and Chesapeake, again, this is the CDC affidavits, which right now aren't in effect, but a lot of the principles from the CDC affidavits have been adopted by the courts as far as heightened requirements that must be met in order to get possession, and specifically when rent has not been being paid. In the Gardner case, I had the possession order, and I had a lady, when the sheriff showed up, wave a CDC affidavit, in the sheriff's face, and the sheriff's like, listen, we're not lawyers, we're not judges, we're just going to kick this back to the court. And I filed, an immediate hearing on the matter, and the affidavit provides for that, to challenge those affidavits in court. And while this lady, had claimed that she had COVID-related loss of income, it turned out, again, under cross-examination, that she had suffered an injury on the job, and that's why she wasn't at work, and that she had received workers' compensation. She had no actual loss of income. And so we were able to proceed with the eviction. Another example of being flexible and the fact that there is different interpretations of the same law in Virginia Beach, from Norfolk to Chesapeake to Portsmouth to Suffolk to the peninsula. In Virginia Beach, for a time, they had writ hearings. And at a writ hearing, this was something that didn't exist on January 1st, and it doesn't exist as of September 1st. But for several months in between, I get possession orders, which were easier to get in Virginia Beach than in other jurisdictions. But the judge would require that before the eviction proceeded, after the 10-day appeal period expired, that I go and make an affirmation. I had affidavits from the landlord that no CDC application had been made, no rent relief program had been made, no payment offer had been made between the granting of possession and the writ of eviction proceeding the sheriff's office. And often, once we figured out how to manage those, it was me showing up at 8:30 in Virginia Beach, making eye contact with the judge, holding these affidavits up and affirming 5 specific facts. And I was out of the courtroom by 8:45. So while it became a new requirement that required us to navigate it because of our coordination with the clerk's office and the court, we were able to navigate it and figure it out pretty quickly. But this is something that if this pandemic sees a resurgence in the fall, if the CDC decides to try to work around the Supreme Court ruling, that we can see some of these principles coming back in play. Finally, in Suffolk, the General District Court judge there announces the presence of legal aid in the courtroom. And before allowing a possession hearing to proceed, will give tenants who've shown up without a lawyer the opportunity to consult with legal aid to see if they qualify. I was there in April, and I had shown up from Virginia Beach. My landlord client showed up from Surrey. The tenant showed up from Suffolk and got his lawyer to show up from Newport News. And we were all there, we were all present, and the judge refused to hear it, even though all the arguments were ready, all the evidence was ready. He said, well, you guys all showed up, we'll just set a date out for 2 weeks. And that meant 2 more weeks where my client wasn't getting rent. And in this case, the tenant was paying an attorney, where there's further uncertainty for the tenant. We ultimately got possession, and we had a final rent and damages hearing in which back rent, late fees, attorney's fees, and property damage was awarded. And so we got what I would consider to be the just and equitable result for the landlord, but it didn't happen quickly, and it didn't happen easily. This is the CDC declaration. I'm going to move past this because, well, point 2 is important. It includes a statement that the tenant understands they can be liable for perjury for false or misleading statements or omissions on the declaration. Typically, most tenants are just checking all the boxes, and some of these boxes are somewhat mutually exclusive and highlights in court under cross-examination that they didn't actually read what they were swearing to. On the back side, it's even more important here. I'm going to read this out loud if it's too small for you to see. It says, I understand that after I sign, unless I come to an agreement with my landlord, I'm still responsible for back rent, and any fees, penalties, or interest under my lease. I must still follow the conditions of my lease. Unless I come to an agreement with my landlord, if I fail to pay my required payments, I could be evicted when this temporary halt ends. And I can still be evicted for reasons other than not paying rent or not paying a housing payment. There's other ones here, but this is the ones that I've had the most success challenging, because they're typically, if they're not paying rent, they're typically in violation of other clauses of the lease. And they recognize that they still have to pay it. And most of the tenants I've encountered that have attempted to use this to stave off eviction think that it's a get out of rent free card, and that's not. I have had a number of landlords be very satisfied with the rent relief program and find that tenants are more than happy to work with them, and have had really good success. But I found that this varies substantially based on jurisdiction and when the rent relief program was applied for. So sometimes, and it really is a choice from landlord to landlord, you may want to inform your tenant that if they have difficulties, that these programs are available, and it gets the landlord paid, and it keeps the tenant from having eviction on their record. Other times, it's often a smokescreen for a problem tenant that is just using any excuse. What I've found here recently is that when we file our eviction notice, we will send an application and require them as a requirement for the landlord to apply on their behalf as required by the law to cooperate by providing the required information. And usually if you're getting a notice of eviction, because we will file the, we'll get the court date, and we'll file it far enough out, and we'll provide the notice of the court date, the notice of the eviction with the legal aid. We'll provide a statement of the landlord, the tenant's right and responsibilities as required from the 2020 update, and we'll provide that application. And typically, if the tenant is looking at that, they're saying, well, now I'm being evicted, and they're not sending anything back, and we can say honestly to the judge, Your Honor, we provided the application, we requested this information, the tenant is refusing to cooperate, therefore we're proceeding as permitted under the act. Again, the tenant is not permitted to otherwise breach the lease, unauthorized, I should read unauthorized pet, domestic disturbances, etc. And a reminder that the landlord still has a responsibility for providing a fit and habitable home to the tenant. And if there is not adequate notice from the tenant when there's a problem, well, then the tenant is in breach of the lease and the landlord is being barred from performing their duties. So what actions are tenants taking in this environment? One thing that I've seen that falls outside the act is saying no to the court claiming COVID. I've got to go back to court in Hampton tomorrow for a tenant who, has not showed up to any hearings so far. And last time, sent a note said, hey, I've got COVID, I've got a quarantine. That's not the first time, but the judges are reluctant to order possession under the circumstances. But I'd also say the upshot to this for the patient, persistent landlord and attorney is that judges have their limits too. And the judges, by and large, I think that we are fairly blessed here in Southeast Virginia to have judges that respect the law, that balance the equities, that don't try to substitute their judgment either for the parties who are entering into the lease or for the government that's directing them. And there are exceptions to that, but by and large, I think that we've had fair judges. And if you're patient, persistent, we'll ultimately get a just result. I had one where I literally appeared 6 times and I had a tenant who didn't show up for the initial possession hearing, had it continued. We got possession, didn't show up for the subsequent hearing. We had a final rent and damages initial notice, then we had a hearing. They showed up an hour after the judge granted default judgment, and the judge allowed it to be reopened. I had to show up on the hearing to reopen it, and they sent a final hearing. I showed up, I got $26,000 in judgment, and then they showed up an hour later, and I was still in the courthouse, so I was able to go in front of the judge, and the judge reamed the tenant out. The tenant had, complained that he had a family member die the previous day, and the judge essentially said, listen, the landlord and the landlord's attorney have been here 6 times in the last 3 months, and this is the first time you're appearing before a judge, and even now it's not on time. This is the end of the road. If you don't have anything, any receipts, any et cetera, et cetera, et cetera, I'm granting judgment and it will be undisturbed, and you can post a $26,000 appeal bond if you're still not happy. And that tenant did not appeal. So again, the judges are trying to be respectful of the law, trying to give tenants the benefit of the doubt, but at the end of the day, they're smart and reasonable people and see through excuses. And for the patient, persistent landlord and property manager, if you stick with it, you will get the judgment that you're entitled to. But really, I've focused on the bad news. What I found is that many tenants are paying rent. Many landlords and many tenants are communicating very, very well. And tenants that have a legitimate loss of income or difficulty, I had landlords that come to me on advice as to how to structure before the CARES Act was passed. This was back in mid-March last year, before the CARES Act was passed, before any moratorium had come into play, before a state of emergency existed in Virginia, said, hey, John, I think that some of my tenants are going to have a hard time paying rent over the next couple months as we figure this COVID thing out. I want to be able to just tell them, don't worry about April. We can do a repayment plan, over the course of the rest of the summer, if this thing kind of like hits us and then goes away, just to help me take a look at that. And that was on their own initiative. That was a property manager who managed over 400 units and said, I want to get out ahead of this. And I found that in Virginia here, that's been the attitude of how can we work together, and you pay as much as you can and get any assistance that you're entitled to. What can we do to work with you to keep good tenants in properties and keep landlords happy? I've not had an experience of the eviction tsunami that has been predicted again and again and again. It just hasn't happened. One of the things is we're in a great market for selling your property, and so that provides incentives. So if the landlord has said, hey, this is a tough environment to be a landlord, I'm ready to get out of business, and I want to take advantage of a hot seller's market and sell the property. I've negotiated a number of, essentially cash for keys deal where landlords are willing to forgive, a couple months of unpaid rent. As long as the tenant gets out of the property, leaves it in reasonably good condition. Yeah, we'll even give you your security deposit back. Good luck. And I'm going to sell my property and make a ton of money on it so that a couple months rent becomes a drop in the bucket, cost of doing business, and that has sort of served as a buffer on this being a major eviction problem. And again, you as a property manager can play a role in that. And if you need an attorney to play a role in that, be more than happy to do so. And have been very successful in providing, happy landlords, happy property managers, and allowing the tenant to get out without having eviction on the record. As this is a legislative update, I want to, bring to your attention that in the regular session of the General Assembly, with the regular July 1st change in the law, military status has now become a protected class under the Virginia Fair Housing Act. We saw last year that source of funds, let's see here, became I guess I can't click on this slide, became a protected class as well, so that we could not discriminate for, against Section 8 fair housing choice voucher applicants. Now you can't discriminate on military status. I'm familiar with any property manager or landlord who intentionally discriminates on a military member in providing application release. But what has been common practice was SCRA waivers, or the Service Member Civil Relief Act waivers. These are permitted under federal law, where a service member at the beginning of the lease will essentially say, hey, listen, if I get, PCS, if you're not military familiar, permanent change of station orders that take me outside of my, 35 miles of my home base, then I can terminate this lease. And the law provides, the federal law provides some notice. You can waive that and renegotiate the lease where, hey, you're paying a 2-month, lease release fee. There's various SCR waivers that I've seen that have been standard practice in this area. My understanding of the law would say that those would no longer be permitted, even though they're permitted under federal law. That this change in Virginia law would render those SCRA waivers unenforceable and potentially open up landlords and property managers to liability for violation of the Fair Housing Act. You can read that even further on in Virginia Code Section 36-96.3. However, as a general, and again, I ought to point out at this time, the disclaimer that's been on the bottom of all the slides, that this is an informational presentation only, and that none of the information that I provides a basis for attorney-client relationship. I encourage everybody, if you have a question, this is about a change in the law, how it affects you, how it affects your business, how it affects your leases, your relationships with your landlords, your tenants, that you contact an attorney, be it myself or another firm directly, for clear application of the law to your particular facts and circumstances. However, in general, I would advise or counsel that these could be found unenforceable and it's not worth the liability, and I encourage you to scrap the SCRA waivers altogether. This again was, became a matter of law as of July 1st, 2020. It is the Virginia Statement of Tenants' Rights and Responsibilities, more commonly known as the Tenants' Bill of Rights. In order to proceed for enforcing the lease, you need to provide this to your tenants. Hopefully most of you are already doing that. Often what I have the landlords do is provide a link to the rights and responsibilities and ask them to sign this and say, hey, listen, you've been informed of this. One of the things that we've done in evictions, if these are older leases that predate the law change, is have them send this and have the landlord sign it, indicating that they sent it. That way we can at least affirm to the judge that we have sent them notice of the rights under the law. I've not seen this very strictly enforced, but I have a feeling that once it starts being enforced in the courts, that it will be, so I encourage you to get out and comply with the law, get out ahead of it, provide this to your tenants. Here is, again, an outside the code update. I recently had a trial that concerned, among other things, the return of security deposit was being contested by the tenant. And in the past, I've seen this where, hey, if everything was in good working order at the beginning of the tenancy, at the end of the tenancy, if it's broke and you hadn't provided notice, then the tenant's responsible. My client in this case had provided the disposition of security deposit within 45 days, had certain things repaired and completed, kept good receipts for that, and provided the notice of disposition. The tenant, did nothing, and then 6 months later sued them for the security deposit. And the judge, I've only seen this once, but it was very informative, essentially redlined the security deposit disposition, said, this is allowed, this isn't, this is allowed, this isn't. And she talked to me afterwards. She had graduated from my law school. I, was very respectful. Always be respectful of the judge, even if you strongly disagree with them in court. And then afterwards said, hey, listen, I'm the newest judge appointed to this bench. And I went to what's essentially a judge's school, and this is what they're teaching. And it's a bit of a change in a reasonable wear and tear standard. And your lease required them to have a walkthrough at the beginning. And while you each have different copies of that, here's how, if you want to win this particular case all the way in the future, and I got, my client got to keep some of the money, but, the other stuff was disallowed. The best practice is to take use of the code, which permits you as a landlord to adopt a written policy that the tenant takes the premises in fit and habitable condition as is condition and warrants that everything is in good working order. In the alternative, be very diligent in doing a walkthrough inspection at the beginning of the tenancy in which you note each and every defect and have it signed so that you can return to that at the end of the tenancy if things go south. So my goal for you as a lawyer is to limit your responsibility as an agent and provide maximum flexibility. Now, this applies both to difficult tenants and difficult landlords. You don't want to be on the hook if your owner is not responsive to doing the required repairs. So if there's a notice from the tenant that says, hey, listen, I'm having an AC issue, and the landlord says, I fixed it a couple of years ago, it's probably fine. And then that tenant goes to the court and does a tenant's assertion, liability can fall on you. You want a well-written property management agreement that clearly outlines the responsibilities of the property manager, or excuse me, of the owner, so that you can terminate if they're not responsive. Now, obviously, you don't want to have a reputation for somebody who fires a tenant, fires a landlord as soon as the going gets rough. But you also don't want to be stuck riding a sinking ship either. All of us in business understand the 80-20 rule that 20% of your tenants, clients, owners, provide 80% of your issues. You want to be able to mitigate that when the time comes so that you're not stuck, right? Tenant's not getting paid, you're not getting paid. So you want to make sure that you're in a position to manage that relationship effectively. Here's some resources for property managers. And I believe we provided this slide. I have emailed out a similar document that you can keep handy next to your desk or on your desktop with all these as active links that provide some of the legal language and some additional resources. As a reminder, Hanger Law can assist you in drafting and reviewing lease agreements, property management agreements, and your notices. We can provide you legal counsel and representation in court to evict tenants who are not paying rent or negotiate a mutual lease. Landlords whose tenants are not paying rent, if you want to just serve as a conduit and say, hey, our property management agreement doesn't involve us for providing legal counsel. However, we're very confident in Hanger Law, so why don't you represent them directly and leave us a confidentiality waiver so that the property manager can communicate with the attorney. We can discuss how to handle repair requests from tenants, what's required by the law, what's advisable under the law, what's not necessary under the law, and what's prohibited, and negotiating out-of-court settlements for past due rents. We can also give you guidance on sale foreclosures, which the mortgage foreclosure process, we believe, will be lifted soon. We can provide foreclosure defense, loan modifications, short sales, and collections of back rent owing to your landlord. So even when you get that money judgment, actually getting that collected. We can set up your business as an LLC. We can provide advisement, and we do full service estate planning, wills, trusts, powers of attorney, deeds pursuant to death, transfer on death deeds, and advice in selling and buying property that's held by estates. I'm going to leave this slide up. This provides contact information for us at Higher Law. We're happy to have a consultation with you at any point. And this is my assistant Emma's email address, who essentially can provide you copies of this information. She's sort of my brain behind my mouth, I guess. So I show up and do these presentations, but she's the one who kind of keeps me organized, on task, and delivering for clients. I'm going to check and see if I've got any written questions. And it looks like I've got one in chat. This is from Christine. If you have someone that was paying rent then and now is getting Section 8 and your owner doesn't want to do that, is that grounds for lease breakage? No, again, that would fall under the protection for source of funds. And you cannot discriminate on source of funds, especially if you're a property manager. There are still some exemptions for individual owners or landlords that are managing their own property that own 4 or fewer properties. But a change in the basis of the funds would not be a basis for terminating that lease. However, you don't have to renew, and you don't have to cite a grounds for non-renewal, termination notice to vacate. So if you have a 12-month lease and halfway through somebody's getting Section 8 and the owner doesn't want to do that, and oh, by the way, if the property doesn't comply, which is a separate presentation about property compliance with Section 8 requirements, then that may be a different grounds, but the sole basis of a change in the source of funds is not legally sufficient grounds for terminating that lease. I'll see if I can type that up while I wait, see if there's any other questions. Well, it's been a pleasure presenting this morning. It is nearing noon and I've got no other questions. So please feel free, as this lecture has been recorded, to contact me, contact Emma, contact Higher Law if you have any further questions. And we'll be happy to provide you a 50% discount on any consultation if you refer to this presentation. Thank you.